Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rakeda of Rakeda Law, a small law firm in central Minnesota, and happy Thanksgiving. Happy Thanksgiving to you all. I hope you had a wonderful time somehow amid all of the lunacy of this absolute dumpster of a year. I hope you have found not only things to be thankful for, people to be thankful for, but a time to spend being thankful for those things and being thankful with those people. So from the bottom of my cold, withered, lawyer, soul-removed heart to yours, happy Thanksgiving. It is genuinely my favorite holiday of the year. And it is also what has put me in a profoundly negative mood about all of this virus stuff, because they are taking away things that we value. The nebulous they, whoever they may be, but it's government. That's the end, because only government can take away things that you value. If you think about it, private businesses can't take away things from you. They can just refuse to provide them. A government is what it takes to remove something from you. So let's never forget, hashtag never forget, who is responsible for this. They can actually eat all of the bag of Christmas cocks in the world. they just suck. For those of you who are joined me earlier, if you are a channel member, or if you are a patron of the show, I did do a cooking stream earlier. I did smoke a turkey. I took a picture of it. It was delicious. You can never, translate taste into a picture, but let me get it pulled up for you. I'll show you. Oh, God, I got to scroll back here. I will show you my turkey. Pre-carved. Still in the roasting pan. But I cooked it on my smoker. I smoked a turkey. It's the first time I've smoked a turkey, which it turned out, just like everything else that I've smoked, fantastic. Really easy to do. Easier, I think, than roasting a turkey in the oven. Here we go. Oh, I love how food always looks less appetizing in a picture. But anyway, here, I'll show it and you can make fun of me, but that's okay. I don't know if you will, but you can. I'll allow it. Here you go. Here's the smoked bird in its roasting tray. I guess I could zoom in a little bit. There you go. It was delicious. It was quite tasty, very juicy. But yeah, and the gravy that I made from it was even The gravy was delicious. So here's the thing I learned about smoking turkeys. I learned some valuable lessons today. One, make sure your roasting pan is big enough. If you notice, that roasting pan was what we would call cozy. Because when Lady Rackets went to the store last minute yesterday to pick up some things, I forgot to say a big giant disposable roasting pan. Because all I had were little disposable roasting pans. And if you're smoking something, I don't want to put my good turkey roasting pan in the smoker because that smoky, sooty grime gets on the metal and it doesn't really come off. I mean, you don't care that it's in your meat and that you're going to ingest all that smoky, sooty grime, that residue from smoking food. You just eat that. That's fine. But having it on nice cookware sucks. And so I didn't, I didn't want to, my roasting pan, I have a really nice high quality one for roasting for Thanksgiving specifically, but I didn't want that to get all nastied up in the smoker. So I should have had Lady Rackets get a turkey-sized roasting pan, but I didn't. So I learned that you should have that because when you smoke a bird, they're juicy out of their minds. I mean, you get drippings and everything. It's great, terrific. Did the gravy have a smoke flavor to it? A little bit, yeah. The gravy was also spicy because I added crushed red pepper to my turkey rub, and that infused the turkey fat as it was coming out of the bird with spicy, which was really, really surprising and delicious, and it went into the gravy. So what I was saying is I learned that there's a lot of drippings. I actually had to drain the tray a couple hours into, well, just once, like about 3/4 of the way through. I had to drain the tray so that it didn't like flood over and make a huge mess in my smoker, because that would have been lame. Here's the other thing I learned. You know those gloves, those woven Kevlar oven gloves that you have with the fingers and everything, so they're real nice and mobile, and they're just cloth, but they keep your hand nice. If you pick up a turkey pan and you start pouring the turkey drippings into like a large receptacle, and those drippings go out the side of the pan because there's a lot, and onto those gloves, they actually go in the glove right onto your skin. The like boiling 230-degree drippings go onto your hand. And then what happens is your hand is trapped with the scalding liquid. So then you scream a lot and you use a bunch of profanity outside in the middle of November or the end of November in Minnesota. And you rip the glove off after you've gingerly set down the turkey. You then rip the glove off and scream at your hand. And then you go inside and cool it down as fast as possible. It was great. It was great. But it was just a superficial burn. I didn't have any like, it was only red for like, an hour or so, and now it's good. I've burned myself plenty of times in the kitchen. This was not anything consequential. But anyway, that was fun. Very fun. You read the title, it's Karen continues instead of Kraken. Yeah, that's true. Did I tell you guys, real quick, we'll get back to this in just a second. I gotta get back to our page anyway. What, 40? 42? I think? 44? Oh no, here we are. Page 45. Did I tell you guys I had a wonderful customer service encounter the other day? Not Best Buy. They make oven mitts that are entirely covered with silicone on the back. No, I have that Stabby McStabs wood. I have those too. I have silicone oven mitts as well. Let me tell you a very brief story, because it's Thanksgiving, man. We can't go directly into this. We gotta send some joy. We gotta send some joy each other's way. You didn't get to be around your family and laugh at them as they argued with each other. Could you imagine what Thanksgivings would really be like this year if you got the traditional family vibes with everybody screaming about like Biden and Trump? Oh my God, it could be great. But okay, so we got to do that. But here's the quick story, and I promise it is quick. The other day, I'm sitting around my house, and I get a phone call. And it is the dentist. It is the dentist. And so, and they're calling about my son. Stop me if I told this, and I'll continue telling it. They're calling about my son because he's got an appointment coming up in December. And they call up and they say, hey, we're calling because we need to reschedule your son's appointment. It's at 11 a.m. and we want to push it back to 2. And I said, let me look. They immediately asked for my wife. And I'm like, well, she didn't want to talk to the dentist. So I'm like, she's not here. Then they're like, can we push it back to 2? Let me look. I look at the calendar and there's activities that my kids do. And we had specifically scheduled it at 11 so that he could make all of his activities. But at 2, that's right in the middle of one of his things. So I'm like, hold on. Let me check. So I asked my wife and I'm like, what happens? Can we push this to 2? She's like, I don't want to have him miss his things. We've scheduled around stuff all over the place so that we don't have to have them miss their activities. Because, again, with COVID this year, the amount of activities that they get is already limited. So we want to make sure they get a chance to have some social interaction with other kids and do, things outside of the home. We find that to be important. So I said, okay, I'll call and ask when the next time they could schedule him. So they said, yeah, that's not going to work. When's the next time you could schedule him? And he said, well, you'd have to call back at the end of December because we're already booked through January. So you call back at the end of the December and then we'll book him in February, or no. Yeah, we'll try and book him in February. And I'm like, wait, if you're already booked out through January, if I call at the end of December, you're going to be booked through February. That doesn't make any sense. So we're looking at April or March, I guess, March or April for him to get into his appointment. That's no good. And so I'm like, that sucks. So I tell Lady Rackets and she says, we've been hosed by appointments lately with the house stuff. We've been hosed with Best Buy. We've been hosed. So she says, why can't we just keep maybe they'll just let us keep the old one, very sarcastically. And I'm like, yeah, what the hell? So I get back. I said, that's not going to work. I've got an idea. Why don't we just keep the 11 o'clock appointment? And they said, yeah, okay, we can do that. I'm like, what the hell did you call me for? What is this? Why would you do this to me? You didn't have to reschedule shit. We already had the appointment and now you just kept it. Idiots. That's pissing me off. Okay, that's it. Just a short story. It worked out. It was great. It worked out just fine. We got to keep the appointment we had. I'm going to try that every time someone tries to reschedule anything with me ever. Okay, Bad Vibe says these governors are callous, ugly, nasty trash individuals. They don't fear being fired because it literally takes an act of Congress or an election. Yep. All right, let's get to the lawsuit. I know people are waiting for that, and you don't come here for my boomer stories about trying to be a dad when everybody else in the world that you have to interact with is an idiot. So, am I going to cover the SCOTUS ruling from last night? I don't think we'll get to it this night. Here's a short story. 5-4 SCOTUS rules that COVID restrictions on synagogues and churches in New York are unconstitutional. Funny story, they'd had 2 similar cases like that while the Archlich, Ruth Bader Ginsburg, was still alive, and those both went the other way. The other way, 5-4. Or maybe 6-3, I don't know. Those went the other way, but now that Amy Coney Barrett is on the bench, it went 5-4 in favor of liberty. So that was good. I don't know the extent of that order. I don't know if it applies outside of New York. I haven't read the opinion, but a step in the right direction and a good first move by Amy Coney Barrett. I know some people have been have expressed concern that she will just side with the government on lockdown issues. Here she did not. So that was good. Whether or not, that's indicative of any other decision remains to be seen. But for this one, it was good. Roberts did not gain some sanity, Brian and Taryn. Roberts voted with the liberals, which is why it was 5-4 instead of 6-3, because Roberts is a giant chump. All right. So here's where we left off yesterday. Page 45, paragraph 104. And let's see if we can get through this document today. Someone earlier asked, do I know why the exhibits are under seal? The exhibits are probably, they're filed under seal with a request to remain under seal, although that's up to the court. If the court decides to unseal them, they'll be unsealed. But probably due to harassment and threats and all of that stuff that we've seen at every single stage of this election fiasco. Anyone on the side of Trump gets their life threatened, their family threatened, their address released. All of that stuff happens immediately. So they're likely just taking as much precaution as possible. Luminaire, the law is actually not clear. I think that's the problem. The law should be clear, but it's not. Okay, on we go. Smartmatics incorporators and inventors have backgrounds evidencing their foreign connections, including Venezuela and Serbia, specifically its identified inventors. Applicant Smartmatic Incorporated, or Smartmatic Corporation. Inventors, Lino Iglesias, Roger Pinate. That's it. I'm reading all of these American. Antonio Mujica, Paul Babic, Jeffrey Nevada, Danny Farina, Rodrigo Menzies, Salvador Ponticelli, Gisela Gonclaves, Urim Caruso. So there you go. That's what we've got. The presence of Smartmatic in the United States, owned by foreign nationals, and Dominion, a Canadian, oh, now we know, company with its offices such as the Office of General Counsel in Germany, would have to be approved by CFIUS, which was created in 1988 by the Exxon-Florio Amendment to the Defense Production Act of 1950. CFIUS's authorizing statute was amended by the Foreign Investment and National Security Act of 2007. As amended, Section 721 of the DPA directs the president acting through CFIUS to review a covered transaction to determine the effects of the transaction on the national security of the United States, citing 50 U.S.C. 2170b1a. Section 721 defines a covered transaction as any merger, acquisition, or takeover by or with any foreign person which could result in foreign control of any person engaged in interstate commerce in the United States. Review of covered transactions under 721 begins with CFIUS. As noted, CFIUS is chaired by the Treasury Secretary, and its members include the heads of various federal agencies and other high-ranking government officials with foreign policy, national security, and economic responsibilities. Ugh. Oh my goodness. Then Congresswoman Carolyn Maloney wrote October 6, 2006 to the Secretary of Treasury Henry M. Paulson Jr., Hank Paulson, this is Obama years, objecting to approval of Dominion Smartmatic by CFIUS because of its corrupt Venezuelan origination, ownership, and control. See attached hereto as Exhibit 24, Carolyn Maloney letter of October 6, 2006. Our own government has long known of this foreign interference on our most important right to vote, and it either responded with incompetence, negligence, willful blindness, or abject corruption. In every CFIUS case, there are 2 TS-SCI reports generated, one by ODNI on the threat and one by DHS on risk to critical infrastructure. Smartmatic was a known problem when it was nonetheless approved by CFIUS. See, so here's the problem. I mean, I'm not sure where she's going with this argument, but it was reviewed and approved. So it must not have been that much of a problem. That's how you have to read that. That's how the court will read it. Okay, guys. Your boy Zach's case is still going. There's no news. Vic Mignogna's case, still waiting on the appeal. There's no news. Get used to the fact that there's no news. It's only been 2 months. They have up to 6 months to submit their briefs to each other, and then up to 3 more months after that to review them. It could be a very long time in Vic's case. It could be a long time in your boy Zach's case. We just have to see. All right, I just have to address it because people ask all the time. The Wall Street Journal in 2006 did an investigative piece and found that Smartmatic came to prominence in 2004 when its machines were used in an election to recall President Chavez, which Mr. Chavez won handily, and which Venezuelan opposition said was riddled with fraud. Smartmatic put together a consortium to conduct the recall elections, including a company called Bizda Corp., in which Smartmatic owners had a large stake. For a time, the Venezuelan government had a 28% stake in Bizda in exchange for a loan. Bizda paid off the loan in 2004, and Smartmatic bought the company the following year, but accusations of Chavez government control of Smartmatic never ended, especially since Smartmatic scrapped a simple corporate structure in which it was based in the U.S. with a Venezuelan subsidiary for a far more complex arrangement. Company said it made the change for tax reasons, but critics, including Rep. Carolyn Maloney and TV journalist Lou Dobbs, pounded the company for alleged links to the Chavez regime. Since its purchase by Smartmatic, Sequoia's sales have risen sharply to a projected $200 million in 2006, said Smartmatic's chief executive Anthony Mujica. Indeed, Mr. Kobuchi testified through his sworn affidavit that he born in Venezuela is cousins with Anthony Mujica, and he has personal knowledge of the fact that Anthony Mujica incorporated Smartmatic in the U.S. in 2000 with other family members in Venezuela listed as owners. He also has personal knowledge that Anthony Mujica manipulated Smartmatic to ensure the election for Chavez in the 2004 referendum in Venezuela. He also testified through his sworn affidavit that Anthony Mujica received tens of millions of dollars from 2003 to 2015 from the Venezuelan government to ensure Smartmatic technology would be implemented around the world, including in the U.S. See attached the affidavit of Juan Carlos Kobuchi. I think that it was supposed to be he, comma, born in Venezuela, comma, or it was supposed to be he was born in Venezuela. Another affiant witness testifies that in Venezuela, she was in an official position related to elections and witnessed manipulations of petitions to prevent a removal of President Chavez, and because she protested, she was summarily dismissed. Corroborating the testimony of our secret witness and our witness, Mr. Kobuchi, cousin of Anthony Mujica, who began Smartmatic, and this witness explains vulnerabilities of the electronic voting system and Smartmatica to such manipulations. All right. Again, I said this yesterday, so I haven't been saying it today, but it bears repeating. They're laying out a very good case about why Smartmatic was bad in Venezuela. They're not right now establishing in any way that Dominion has been bad in the United States. I'm hoping they get there. You can't just do an associative guilt thing. It's not even admissible evidence to say that to try and use the fact that they did something elsewhere at another time to prove that they did it here and now. Specific vulnerabilities of the systems in question that have been documented or reported include barcodes can override the voter's vote, as one University of California, Berkeley study shows. In all three of these machines, including Dominion voting systems, the ballot marking printer is in the same paper path as the mechanism to deposit marked ballots into an attached ballot box. This opens up a very serious security vulnerability. The voting machine can make the paper ballot to add votes or spoil already cast votes after the last time the voter sees the paper, and then deposit that marked ballot into the ballot box without the possibility of detection. So yeah, this is a problem with barcodes because the person who looks at a barcode, since they're not a freaking computer, can't read what the barcode says. So if it's a barcode that is determining the votes, the person can't validate that they're voting for the right person. The Michigan lawsuit goes hard on Dominion and Smartmatic. Okay, we'll see. We'll see. Again, we'll see how this goes. The voting machines were able to be connected to the internet by way of laptops that were obviously internet accessible. If one laptop was connected to the internet, the entire precinct was compromised. We discovered that at least some jurisdictions were not aware that their systems were online, said Kevin Skoglund, an independent security consultant who conducted the research with 9 others, all of them long-term security professionals and academics with expertise in election security. Vice, August 2019. So again, we've got them laying out a case for something that already happened somewhere else, but not in this election today. October 6, 2006, Congresswoman Carolyn Maloney called on Secretary of Treasury Hank Paulson to conduct an investigation into Smartmatic based on its foreign ownership and ties to Venezuela. Congressman Maloney wrote that it is undisputed that Smartmatic is foreign-owned and it has acquired Sequoia. Smartmatica now acknowledged that Antonio Mujica, a Venezuelan businessman, has a controlling interest in Smartmatica, but the company has not revealed who all the other Smartmatic owners are. It says Smartmatica, Smartmatic. Are these different? Are they the same? Are these quotes accurate? This is weird. Dominion got into trouble with several subsidiaries it used over alleged cases of fraud. One subsidiary is Smartmatic, a company that, quote, that has played a significant role in the U.S. market over the last decade, according to a report published by UK-based Access Wire. Litigation over Smartmatic glitches alleges they impacted the 2010-2013 midterm elections in the Philippines, raising questions of cheating and fraud. An independent review of the source code used in the machines found multiple problems, which concluded, quote, the software inventory provided by Smartmatic is inadequate, which brings into question the software credibility. Dominion acquired Sequoia Voting Systems as well as Premier Election Solutions, formerly part of Diebold, which sold Premier to ES&S in 2009 until antitrust issues forced ES&S to sell Premier, which then was acquired by Dominion. Dominion entered into a 2009 contract with Smartmatic and provided Smartmatic with the PCOS machines, optical scanners that were used in the 2010 Philippine election, the biggest automated election run by a private company. The international community hailed the automation of that first election in the Philippines. The results transmission reached 90% of votes 4 hours after polls closed, and Filipinos knew for the first time who would be their new president on election day. Keeping with local election law requirements, Smartmatic and Dominion were required to provide the source code of the voting machines prior to elections so that it could be independently verified. Okay. You keep almost falling asleep because this part of the filing is boring, and this is all talking about everything else. In late December of 2019, 3 Democratic senators, Native American Warren, Klobuchar, Wyden, and House member Mark Pecan, wrote about their particularized concerns that secretive and trouble-plagued companies have long skimped on security in favor of convenience, in the context of how they described the voting machine systems that 3 large vendors, ES&S, Dominion Voting Systems, and Hart Intercivic, collectively provide voting machines and software that facilitate voting for over 90% of all eligible voters in the U.S. Again, as way back in December of 2019, Democrats were complaining about the security of electronic ballot counting. This is way better than the Dominion stuff so far, because they're just look, last year the Democrats said that this is going to be a problem, and now it is, and they're trying to deny it. It's great. It's great. Senator Ron Wyden, Democrat from Oregon, said the findings, insecurity of voting systems, are yet another damning indictment of the profiteering election vendors who care more about the bottom line than protecting our democracy. It's not their job to protect your democracy. Like, that's silly. It's also an indictment, he said, of the notion that important cybersecurity decisions should be left entirely to county election offices, many of whom do not employ a single cybersecurity specialist. An analysis of the Dominion software system by former U.S. military intelligence expert concludes that the system and software have been accessible and were certainly compromised by rogue actors such as Iran and China by using servers and employees connected with rogue actors and hostile foreign influences, combined with numerous easily discoverable leaked credentials. Dominion neglectfully allowed foreign adversaries to access data and intentionally provided access to their infrastructure in order to monitor and manipulate elections, including the most recent one in 2020. An expert witness in pending litigation in the United States District Court, Northern District Court of Georgia, Atlanta Division, specifically testified to the acute security vulnerabilities, among other facts, by declaration filed on October 4th. Attached here too, and this is the Hursty Declaration, wherein he testified or found the failure of the Dominion software, quote, to meet the methods and processes for national standards for managing voting systems problems, and should not be accepted for use in a public election under any circumstances. In Hursty's declaration, he explained that, quote, there is evidence of remote access and remote troubleshooting, which presents a grave security implication, and certified identified vulnerabilities should be considered an extreme security risk. Hari Hursty also explained that USB drives with vote tally information were observed to be removed from the presence of poll watchers during a recent election. The fact that there are no controls of the USB drives was seen recently the lack of physical security and compliance with professional standards. In one Georgia county, where it is reported that 3,300 votes were found on memory sticks not loaded, plus in Floyd County, another 2,600 were unscanned, and the found votes reduced Biden's lead over Donald Trump. Again, going back to those two counties. But, Gotcha Son says every 500 likes I drink. Game on, Nikki. I mean, if you wanna play, I think I'll win. They are typos, propaganda, and I'm not hammering on them too hard. This is written in haste. I'm waiting for my first drink, though. You guys got to hit 500 likes for me to hit that first drink. And it is Heyman's Old Tom Gin. All right. Bob the Troll King says, be right back writing a script that creates accounts and likes. Time to drink. There we go. It's the first one. That always makes me feel like a degenerate when I just drink a shot of gin and it doesn't bother me. Oh no. In the prior case against Dominion, Supra, further implicating the secrecy behind the software used in Dominion systems, Dr. Eric Coomer, a vice president of Dominion Voting Systems, testified that even he was not sure of what testing solutions were available to test problems or how it was done. I've got to be honest, we might be a little bit out of my bounds of understanding the rules and regulations. In response to a question on testing for voting systems problem in relation to issues identified in two counties, he explained that, Your Honor, I'm not sure of the complete test plan. Again, Pro V&V themselves determine what test plan is necessary based on their analysis of the code itself. Hursty stated within said declaration, the security risks outlined above, operating system risks, a failure to harden the computers, performing operations directly on the operating systems, lacks control of memory cards, lack of procedures, and potential remote access are extreme and destroy the credibility of the tabulations and output of the reports coming from a voting system. Again, this still is the same issue. You've got, you're complaining about stuff that already happened. And the fact that there's a guy who's talking about how they did testing and they still use the system, this stuff is not good evidence. It's not helpful to the case at the moment, unless they go somewhere else. Rather than engaging in an open and transparent process to give credibility to Georgia's brand new voting system, the election processes were hidden during the receipt review, opening, and tabulation of those votes in direct contravention of Georgia's election code and federal law. I guess that's closer. House of Representatives passed H.R. 2722 in an attempt to address these very risks identified by Hersey on June 27, 2019. The bill addresses election security through grant programs and requirements for voting systems and paper ballots. The bill establishes requirements for voting systems, including that systems 1. Use individual, durable, voter-verified paper ballots. 2. Make a voter's marked ballot available for inspection and verification by the voter before the vote is cast. 3. Ensure that individuals with disabilities are given an equivalent opportunity to vote, including with privacy and independence, in a manner that produces a voter-verified paper ballot. 4. Be manufactured in the United States. And 5. Meet specified cybersecurity requirements, including the prohibition of the connection of a voting system to the internet. Great. Okay. This doesn't really link. I think this section is basically pointless. I think that was roughly like 12 pages of pointless stuff. It just doesn't seem to bolster the case in any way. I know it's nice to have a bunch of allegations about how this company has screwed up in the past, but they're probably, on a motion to dismiss, would be read out of the complaint anyway. So I'm not sure they belong in here at this time. But, I'm not Sidney Powell. Additional specific fraud says on November 4th, 2020, the Georgia GOP chairman issued the following statement. Let me repeat. Fulton County election officials told the media and our observers that they were shutting down the tabulation center at State Farm Arena at 10:30 p.m. on election night to continue counting ballots in secret until 1 a.m. Now that's a problem. That's better. It was widely reported that as of 7 p.m. on Wednesday, Fulton County election officials said 30,000 absentee ballots were not processed due to a pipe burst. Officials reassured voters that none of the ballots were damaged and the water was quickly cleaned up. But the emergency delayed officials from processing ballots between 5:30 a.m. and 9:30 a.m. Officials say they continued to count beginning at 8:30 a.m. Wednesday. Statement from Fulton County continues. Tonight, Fulton County will report results for approximately 86,000 absentee ballots, as well as Election Day and early voting results. These represent the vast majority of ballots cast within Fulton County. As planned, Fulton County will continue to tabulate the remainder of absentee ballots over the next 2 days. Absentee ballot processing requires that each ballot is opened, signatures verified, and ballots scanned. This is a labor-intensive process that takes longer to tabulate than other forms of voting. Fulton County did not anticipate having all absentee ballots processed on Election Day. Officials said they will work to ensure every vote is counted and all laws and regulations are followed. Great. Plaintiffs have learned that the representation about a water leak affecting the room where absentee ballots were counted was not true. The only water leak that needed repairs at State Farm Arena from November 3rd to November 5th was a toilet overflow that occurred earlier on November 3rd. It had nothing to do with a room with ballot counting, but the false water break representation led to everyone being sent home. Nonetheless, first 6 people, then 3 people stayed until 1:05 a.m. working on the computers. An affiant recounts how she was present at State Farm Arena on November 3rd and saw election workers remaining behind after people were told to leave. Plaintiffs have also learned through several reports that in 2010, Eric Coomer joined Dominion as vice president of U.S. Engineering. According to his bio, Coomer graduated from the University of California, Berkeley. Oh, well, that's enough. I know exactly where this guy stands. That's enough. Guys, look, it's only an arena. You can't keep people in an arena if a toilet leaks. Come on. With a PhD in nuclear physics, Eric Coomer was later promoted to Voting Systems Officer of Strategy and Security, although Coomer has since been removed from the Dominion page of directors. Dominion altered its website after Colorado resident Joel Altman disclosed that as a reporter, he infiltrated Antifa, a domestic terrorist organization, where he recorded Eric Coomer representing, "Don't worry, Trump won't win the election. We fixed that," as well as social media posts with violence threatened against President Trump. See Joel Altman interview with Michelle Malkin, dated November 13th, 2020, which contains copies of Eric Coomer's recording and tweets. So, good that guy. Good on him. While the bedrock of American elections has been transparency, almost every crucial aspect of Georgia's November 3rd general election was shrouded in secrecy, rife with errors, and permeated with anomalies so egregious as to render the results incapable of certification. All right. The problem with this is... Wait, is this... Hold on, I just got to look at this. Additional specific fraud. That's not that specific or that additional. The State Farm Arena thing is probably the best part of that section. Coomer, that's a bunch of inference on Coomer, but that's not specific fraud. Multiple expert reports and statistical analyses prove hundreds of thousands of votes were lost or shifted that cost President Trump and the Republican candidates of Congressional Districts 6 and 7 in their races. All right. Here we're going to get into the statistical argument, which is a tough one. The statistical argument is a tough one in court. As evidenced by numerous public reports, expert reports, and witness statements, defendants' egregious misconduct has included ignoring legislative mandates concerning mail-in and ordinary ballots and led to disenfranchisement of an enormous number of Georgia voters. Plaintiffs' experts can show that, consistent with the above specific misrepresentations, analysis of voting data reveals the following. Regarding uncounted mail ballots, based on evidence gathered by Matt Brainard in the form of recorded calls and declarations of voters, and analyzed by plaintiffs' experts Williams M. Briggs, Ph.D., shows based on a statistically significant sample, the total number of mail ballots that voters mailed in but were never counted have a 95% likelihood of falling between 31,559 and 38,886 total lost votes. Okay. This range exceeds the margin of loss of President Trump of 12,670 votes by at least 18,889 lost votes and by as many as 26,196 lost votes. See Exhibit 1, Dr. Briggs' report with attachments. Plaintiff's expert also finds that voters received tens of thousands of ballots that they never requested. Specifically, Dr. Briggs found that in the state of Georgia, based on a statistically significant sample, the expected amount of persons that received an absentee ballot that they did not request ranges from 16,938 to 22,771. This range exceeds the margin of loss of President Trump by 12,670 votes, by at least this many unlawful requests, and by as many as 10,101 unlawful requests. Again, the problem with this one... Okay, we've got two problems here. So, ballots were mailed in, but were never counted. So, where are those? How are they getting this number, and where are those? Unfortunately, we can't see their report and how they've got this number. So that's interesting. This one is voters receiving ballots that they didn't request, and they've got that number pegged somewhere in here, but they don't allege even that these votes were turned in. So that's a tough one there. The widespread pattern, as reflected with the population of unreturned ballots analyzed by Dr. Briggs, reveals the unavoidable reality that, in addition to the calculations therein, third parties voted an untold number of unlawfully acquired absentee or mail-in ballots, which would not be in the database of unreturned ballots analyzed here. These unlawfully voted ballots prohibited properly registered persons from voting and reveal a pattern of widespread fraud down ballot as well. Of course, we can't analyze this evidence because it's filed under seal. So, okay. Further, as calculated by Matt Brainard, there exists clear evidence of 20,311 absentee or early voters in Georgia that voted while registered as having moved out of state. Now, this is great. Specifically, these persons were showing on the National Change of Address database as having moved, or as having filed subsequent voter registration in another state, also as evidence that they moved and even potentially voted in another state. These votes by persons documented as having moved exceeds the margin by which Donald Trump lost the election by 7,641 votes. That's a good section right there. I like that one. This is specific. This tells us where the numbers are coming from, where they're counting, basing them against. That's good stuff. Applying pro rata the above calculations separately to Cobb County based on the number of unreturned ballots, a range of 1,255 and 1,687 ballots ordered by third parties, and a range of 2,338 and 2,897 lost mail ballots, plus 10,684 voters documented in the NCOA as having moved, for a combined minimum of 14,276 missing and unlawful ballots, and maximum of 15,250 missing and unlawful ballots, which exceeds the statewide presidential race total margin by a range of as few as 1,606 and as many as 2,580 in the county of Cobb alone, impacting the Cobb County Republican Party. All right. Yeah, Random Blaze, it's great if it's in the Michigan suit. It's just not that doesn't have any bearing here. I mean, this one is without being able to see the affidavit. Maybe the report and the affidavits are great. I don't know. We can't see them. But without seeing those, this one is the best claim here because it's the clearest one in the complaint. The other ones could be fantastic. We just can't look at it. As seen from the expert analysis of Eric Quinnell, mathematical anomalies further support these findings, which in various districts within Fulton County, such as vote gains that exceed reasonable expectations when compared to 2016, and a failure of gains to be normally distributed, but instead shifting substantially toward the tail of the distribution in what is known as the platykurtic distribution. Dr. Quinnell identifies numerous anomalies, such as votes to Biden in excess of 2016 exceed the registrations that are in excess of 2016. Ultimately, he identifies the counties in order of their excess performance over what would have fit a normal distribution of voting gains. Okay, so they're saying that they took registration increases from 2016 to 2020, and then votes to Biden in excess of 2016, and they're saying that he got more votes than there were more registrations. That actually isn't. I get that it could be statistically anomalous, but this isn't a convincing argument to me in a legal sense. Okay. Revealing at least a list of the most anomalous counties down to the least. These various anomalies provide evidence of voting irregularities. See Exhibit 27, Declaration of Eric Quinnell with attachments. In sum, with expert analysis of William M. Briggs, Ph.D., based on recorded calls and declarations, the extent of missing and unlawfully requested ballots create substantial evidence that the mail ballot system has fundamentally failed to provide a fair voting mechanism. In short, tens of thousands of votes did not count, while the pattern of fraud makes clear that tens of thousands were improperly counted. This margin of victory for Mr. Biden was only 12,670. He cannot withstand most of these criticisms individually and certainly not in aggregate. Cobb County, based on lost votes, unlawfully requested votes, and NCOA data on these facts alone would consume more than the entire margin of the statewide difference in the presidential race. These election results must be reversed. Applying pro rata the above calculations separately to Cobb County based on the number of unreturned ballots, a range of 1,255 and 1,687 ballots ordered by third parties, and a range of the lost ballots, plus these voters documented in the NCOA as having moved, for a combined minimum of 14,276 missing and unlawful ballots, and a maximum of 15,250. Okay, so Cobb County alone, same thing as before. It's the same paragraph as before. Cobb County is enough to swing the election, they're saying. Mr. Brainard, not Brainyard. Mr. Brainard also found a pattern in Georgia of voters register at totally fraudulent residence addresses, including shopping centers, mail drop stores, and other non-residential facilities. In sum, with the expert analysis of William M. Briggs, PhD, based on extensive investigation, recorded calls and declarations collected by Matt Brainard, the extent of missing and unlawfully requested ballots creates substantial evidence that the mail ballot system has fundamentally failed to provide a fair voting mechanism. In short, tens of thousands of votes. I feel like we just read this exact paragraph. Am I having deja vu? This paragraph was seriously just on the page before. A couple of these. It's like they pasted them in twice. Russell Ramsland. No. Look. Here's paragraph 128. Or no, paragraph 126. Applying pro rata the above Cobb County. Here's that in sum. Here's this in sum as well. I guess they added something to it. So they're doing a nice. Here's the pro rata thing. These are very, very similar paragraphs. They're trying to repeat it and carry it home, I guess. It's not a bad strategy. Say it as many times as possible. Russell Ramsland confirms that data breaches in the Dominion software permitted rogue actors to penetrate, and manipulate the software during the recent general election. He further concludes that at least 96,600 mail-in ballots were illegally counted as they were not cast by legal voters. Okay, this is interesting. In sum, as set forth above, for a host of independent reasons, the Georgia certified election results concluding that Biden received 12,670 more votes than President Donald Trump must be set aside. That typo. All right, we're on to the counts. The official counts. Thank God. Woo. Count 1. Defendants violated the election clause in 42 USC 1983. Okay, so we learned from the Pennsylvania case with Rudy Giuliani that you can have all of the great facts in the world, but if you don't incorporate those facts into your actual formal requests to the court, you're going to lose. You're going to lose dramatically. You're going to lose the space lizards, transcendental interdimensional beings, and the communists. You can't do that. You've got to put them into counts. And I'm still waiting. I'm still waiting for you guys to hit 1,000 likes for my next drink, which is very rude of you to keep that from me. So here are the different counts. So the defendants violated elections clause and 42 USC 1983. The 1983 claim is anytime a government official acting under color of law violates a right. The electors clause states that each state shall appoint in such manner as the legislature thereof may direct a number of electors for president. Article 2, Section 1, Clause 2, emphasis added. Likewise, the elections clause of the U.S. Constitution states that the time, place, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. Legislature is the representative body which makes the laws of the people. Regulations of congressional and presidential elections thus must be in accordance with the method which the state has prescribed for legislative enactments. Defendants are not part of the General Assembly and cannot exercise legislative power. Rather, defendants' power is limited to taking care that the laws be faithfully executed. That is the Take Care Clause. There's one in the U.S. Constitution. Apparently, there's one in the Pennsylvania Constitution, Article 6, Section 2. I think they mean Georgia. But I'm not sure. Siren Jag, not a chance. That's a special. That's a special. People have to try harder than that. Because the United States Constitution reserves for the General Assembly the power to set the time, place, and manner of holding elections for the President and Congress, county boards of elections and state executive officers have no authority to unilaterally exercise that power, much less to hold them in ways that conflict with existing legislation. There it is. There, we've hit it. You got to pour it on camera, otherwise people think you're lying. Oh, it's just water. Oh. All right. They have no authority to unilaterally exercise that power, much less hold them in ways that conflict with existing legislation. Defendants are not the legislature, and their unilateral decision to create a cure procedure violates the electors and elections clauses of the United States Constitution. Secretary of State and the State Election Board are not the legislature, and their decision to permit early processing of absentee ballots in direct violation of the unambiguous requirements violates the Elections and Electors Clause of the United States Constitution. Many affiants testified to many legal infractions in the voting process, including specifically switching absentee ballots or mail-in ballots for Trump to Biden. Even a Democrat testified in his sworn affidavit that before he was forced to move back to where he could not see, he had in fact seen, "I also saw absentee ballots for Trump inserted into Biden's stack and counted as Biden votes. This occurred a few times." Plaintiff's expert also finds that voters received tens of thousands of ballots that they never requested. Specifically, Dr. Briggs found that in the state of Georgia, based on a statistically significant sample, the expected amount of persons that received an absentee ballot that they did not request one ranges from 17,000 to 23,000. This range exceeds the margin of loss of the president by a lot. This widespread pattern, as reflected within the population. Now, let's take a brief look here. He conducted a poll based on a statistically significant sample. The expected amount of persons that received an absentee ballot that they did not request. So he did a poll of some representative sample and then extrapolated that out with a margin of error and a methodology. They didn't actually find that this many people received these ballots. They're guessing through a poll where people could lie or, whatever. And a smaller number of people lying makes a bigger difference than normal. So this is not, I don't know. I don't look at his methodology. Again, we can't read it, but I can see a judge going, I'm not convinced. This widespread pattern, as reflected within the population of unreturned ballots analyzed by Dr. Briggs, reveals the unavoidable reality that in addition to the calculations herein, third parties voted an untold number of unlawfully acquired absentee or mail-in ballots, which would not be in the database of unreturned ballots analyzed here. These unlawfully voted ballots prohibited properly registered persons from voting and reveal a pattern of widespread fraud. Further, as shown by data collected by Matt Brainard, there exists clear evidence of 20,311 absentee or early voters in Georgia that voted while registered as having moved out of state. Specifically, these persons were showing on the National Change of Address database as having moved or as having filed subsequent voter registration in another state. Also has evidence that they moved and even potentially voted in another state. And again, this is my favorite part of this claim based on what we can see because it's clear. The numbers have a clear origin. They're over the number that's out there. If they've moved and changed their address, they can't vote in Georgia. And yet, if they did, as absentee or early voters, we've got a problem. This is the... Yeah, I know statistical samples are admissible in court as long as the samples are of a relevant size, but admissibility and usefulness are two different things, for one. And a statistical sample alone is not going to win any case. Like just a statistical sample, you have to have something else. Now, they do have other things. They might not. Without seeing their reports, though, it's hard to judge anything, right? So I'm just pointing out potential issues. I don't know. I can't see the report. So, like, I'm not arguing. I probably am. It's the liquor. Anyway, I like that we can see exactly where these numbers come from. And this is the problem with early voting. If someone votes and moves, where are they supposed to vote? Should they vote in the state where they had absentee voted already? Should they vote in person in the new place? Can they vote in person in the new place? And this is a weird question. What if you move to a state that requires like a 45-day residency before they allow you to vote? Well, you don't live in the old state anymore. You can't vote in the new state, so where do you vote? These are tough questions. I don't have the answer. And that's a question that exists no matter whether you're absentee voting or not. It just becomes more complicated with an absentee vote because they've already cast a vote. Eagle loan, no, it isn't. It's not the same crime, actually. They're different crimes based on the amount you steal. But anyway, I like this section. It's a good one. Plaintiffs have no adequate remedy at law and will suffer serious and irreparable harm unless the injunctive relief requested herein is granted. Defendants have acted and, unless enjoined, will act under color of state law to violate the elections clauses of the Constitution. Accordingly, the results for President and Congress in the November 3rd election must be set aside. Secretary of State in Georgia counties violated the 14th Amendment, U.S. Constitution, Amendment 14, and 1983. Denial of equal protection. So, briefly, to address the standing issue that's plagued Lynn Wood, it's plagued Rudy Giuliani. The standing issue is still a potential hang-up here. Still a potential hang-up, although Sidney seems to have done a better job. Her plaintiffs are the electors. And the argument about the electors is that they presumably have a future property interest at worst in the potentiality of their being certified as an elector. So if they're wrongfully prevented from being an elector as a candidate by the actions that are laid out, then they should have standing to bring the suit because the injury to them is particularized and could be traced to the actions of the defendants, possibly, and is redressable damage that the court should cover. It should pass the standing argument. It should. But it is really tough. It's a really tough question in general as to who has standing to sue. I think Sidney has picked some good plaintiffs for it, though. 14th Amendment provides, nor shall any state deprive the person of life, liberty, or property without due process, nor deny to any person within its jurisdiction the equal protection of the laws. See also Bush v. Gore. Having once granted the right to vote on equal terms, the state may not, by later arbitrary and disparate treatment, value one person's vote over the value of another's. And then we've got Harper versus Virginia Board of Elections. Once a franchise is granted to the electorate, lines may not be drawn which are inconsistent with equal protection of the 14th Amendment. The court has held that to ensure equal protection, a problem inheres in the absence of specific standards to ensure its equal protection. The formulation of uniform rules to determine intent based on these recurring circumstances is practicable and we conclude necessary. Citing Bush v. Gore again. The equal enforcement of election laws is necessary to preserve our most basic and fundamental rights. The requirement of equal protection is particularly stringently enforced as to laws that affect the exercise of fundamental rights, including the right to vote. In statewide and federal elections conducted in the state of Georgia, including without limitation, November 3rd, 2020 general election, all candidates, political parties, and voters, including without limitation plaintiffs, have a vested interest in being present and having meaningful access to observe and monitor the electoral process in each county to ensure that it is properly administered in every election district and otherwise free, fair, and transparent. Oh, okay. Moreover, through its provisions involving watchers and representatives, the Georgia Election Code ensures that all candidates and political parties in each county, including the Trump campaign, have meaningful access to observe and monitor the electoral process to ensure that it is properly administered in every election district and otherwise free, fair, and transparent. CEG, in plain terms, the statute clearly prohibits opening absentee ballots prior to Election Day, while the rule authorized doing so 3 weeks before Election Day. There is no reconciling this conflict. The State Election Board has authority under OCGA to adopt lawful and legal rules and regulations, but no authority to promulgate a regulation that is directly contrary to an unambiguous statute. This rule is therefore plainly and indisputably unlawful. Plaintiffs also bring this action under Georgia law. Grounds for contest. The result of a primary or election may be contested on one or more of the following grounds: misconduct, fraud, or irregularity by any primary or election official or officials sufficient to change or place in doubt the result. When the defendant is ineligible for the nomination or office in dispute, this one doesn't apply. 3. When illegal votes have been received or legal votes rejected as the poll or at the poll sufficient to change or place in doubt the result. So we've got they've got number 1 alleged, they've got number 3 alleged. 4, for any error in counting the votes or declaring the result for the primary or election, if such error would change the result, they may have 4 pled. For any other cause which shows that another was the person legally nominated, elected, or eligible to compete in a runoff or primary election. So again, they have that. So they're saying they're within the statute. They've got claims that are in there. Several affiants testified to the improper procedures with absentee ballots processing, with the lack of auditable procedures with the logs in the computer systems, which violates Georgia law and federal election law. See also 50 U.S.C. 2701 requires the retention and preservation of records and papers by officers of elections under penalty of fine and imprisonment. State Election Board readopted the rule on November 23rd, 2020 for the upcoming January 2021 runoff election. A large number of ballots were identical and likely fraudulent. An affiant explains that she observed a batch of utterly pristine ballots. We read this already. I'm not going to read it again. Same affiant further testified specifically to the breach of the chain of custody of the voting machines the night before the election, stating, we read this one as well. Basically, it was a day and a half. They were asked to sign that they received them on Sunday, but they actually received them in the morning on Tuesday. Defendants have a duty to treat the voting citizens in each county in the same manner as the citizens in other counties in Georgia. As set forth in count 1 above, defendants failed to comply with the requirements of the Georgia Election Code and thereby diluted the lawful ballots of the plaintiffs and of other Georgia voters and electors in violation of the U.S. Constitution guarantee of equal protection. This is not sufficient for standing. This is the same argument Lynn Wood used and lost here. The dilution of a vote has an equal impact to every voter. Every voter. Both parties, every single person within a state. So if it's felt equally, like just let noodle through this. For standing, you have to have a particularized injury, blah, 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 blah. But let's just think on equal protection grounds. If everyone's vote is equally diluted, then everyone is still treated equally. They're given equal inadequate protection of the law. This is a self-defeating paragraph. This should not be their basis for standing, especially on an equal protection case, but it shouldn't be their basis for standing generally. This could be fatal to this count. JB, I can't see dislikes. They don't show up on my thing. I can't see them till later, so I can't. Benjamin 3000. Yes, I'm going to argue semantics. The court rejected Linwood's entire case based on exactly this paragraph. Exactly that. So yes, I'm going to argue semantics because the court is going to argue semantics. Dilution makes it absolutely equal. It's not unequal. Everyone's vote is diluted. Everyone. Every single vote is diluted. Therefore, it's the same. It's the same impact to every voter. Again, it was laid out exactly like this in the opinion against Linwood. This is a bad basis. And again, for equal protection, when you say that it's diluted, that is necessarily equal. The reason the other Pennsylvania case has survived is partly because their votes were taken away. Or no, it's not. Sorry. That case still failed, but they passed the particularized injury prong of the standing argument, which is where Linwood failed in Pennsylvania, because the votes were taken away from the voters. So therefore, they had a particular injury. Dilution is equal to every voter. Having your vote removed is unequal to every voter. I think she's got electors as plaintiffs. Just argue that their elector status was prevented from being enacted by the wrongful acts. Specifically, defendants denied the plaintiffs equal protection of the law and their equal rights to meaningful access to observe and monitor the electoral process enjoyed by citizens in other Georgia counties by mandating that representatives at the pre-canvass and canvasses of all absentee and mail-in ballots be either Georgia barred attorneys or qualified registered electors of the county in which they sought to observe and monitor. I don't know that this is particular injury. Not allowing watchers and representatives to visibly see and review all envelopes containing official absentee and mail-in ballots, either at or before they were opened and or when such ballots were counted and recorded. I don't know if this is equal protection either, in all honesty. They're not alleging that some people were allowed to observe and they weren't. Allowing the use of Dominion Democracy Suite software and devices which failed to meet the Dominion certification reports conditioned for certification. This has nothing to do with equal protection. At all. I don't know. That's weird. Maybe this first one, maybe A. Instead, defendants refused to credential all of the Trump Republicans submitted watchers and representatives and or kept Trump's campaign watchers and representatives by security metal barricades from the arenas where the inspection. This is better. Opening and counting of absentee and mail-in ballots were taking place. Consequently, defendants created a system whereby it was physically impossible for the candidates and political parties to view the ballots and verify that illegally cast ballots were not opened and counted. I would have clarified candidates and Republicans. Republican candidates and Republican Party. Because this looks like it went both ways. If it went both ways, then they were equally treated. That's weird. Hey, is that the Amazing Lucas? What's up, man? If that's you. If that's not the Amazing Lucas, it's just someone with a name. Hey, what's up? How's it going? All right. Many affiants testified to switching absentee ballots or mail-in ballots for Trump to Biden, including a Democrat, testified in a sworn affidavit that before he was forced to move back to where he could not see, he had, in fact, seen. Absentee ballots, that's, yep, okay. For Trump go into Biden. Other Georgia county boards of elections provided watchers and representatives of candidates and political parties, including without limitation watchers and representatives of the Republican and the Trump campaign, with appropriate access to view the absentee and mail-in ballots being pre-canvassed and canvassed by those county election boards and without restricting representatives by any county residency or Georgia bar licensure requirements. Okay. So maybe that's what they're saying here, is that the defendants in this county had different standards than other counties. That might be it. Still a tough one. Bad Vibe says, would the argument that specific districts diluted the vote, which was unequal to the rest of the state? No, because that would be similarly situated voters in the district. It's not particular and specific enough. Dilution is a bad argument. Dilution is a bad argument. Defendants intentionally and or arbitrarily and capriciously denied plaintiffs access to and or obstructed actual observation and monitoring of the absentee and mail-in ballots being pre-canvassed and canvassed by defendants, depriving them of the equal protection of those state laws enjoyed by citizens in other counties. Okay, these two are better so far, because they are stating that this county had specific different requirements and specific different denials. Defendants have acted and will continue to act under color of state law to violate the plaintiff's right to be present and have actual observation to the electoral process as secured by equal protection. Defendants further violated Georgia voters' rights to equal protection insofar as defendants allowed the Georgia counties to process and count ballots in a manner that allowed ineligible ballots to be counted, and through the use of Dominion Democracy Suite, allowed eligible ballots for Trump and McCormick to be switched to Biden or lost altogether. Defendants thus failed to conduct the general election in a uniform manner as required by the Equal Protection Clause of the 14th Amendment and the Georgia Election Code. This is weaker. Because as we've seen in other states, in other states and other lawsuits, the mere fact that county to county have different practices by itself is not sufficient to show a violation of equal protection. You can't just say, well, it's different. You have to show a level of particularized impact that would make the difference matter, tangibly matter. They may have done that. They may have done that up here with their part about why this county was different. I'm not saying they haven't. I don't know. I don't know the answer to that. Only the judge will know the answer to that. But I'm just trying to explain what's going on here, and just the mere fact of having different procedures is not sufficient to say a violation of equal protection. I know logically it is, right? Like, I get it. And in a simple world with normal people reading things, you go, if it's different, then it's different. But the court says, well, if it's different, it's not necessarily different, which is stupid, but that's how it is. They allow different counties to do different things. And a simple test of this is produces an obvious result. Are the counties required to have the same number of polling places or voting or drop boxes or anything like that? No, they're not required to have the same. They're just required to have some sufficient amount, whatever that may be, as determined under the rules. But it wouldn't make sense for Atlanta to have the same amount of votes as like Dalton, Georgia, or whatever. Same amount of voting places. Wouldn't make sense. So you have to start then drilling down into how that specifically impacted people in a way that was different enough to make it matter. So is this a bust? This section might be... The whole lawsuit, I don't think is a bust so far. This section, I'm having I'm having concerns about the standing argument in this section. That's all. I could be wrong. Judge could be in a good mood. I don't know. Okay. Plaintiffs seek declaratory and injunctive relief, holding that the election under these circumstances was improperly certified and that the governor be enjoined from transmitting the certified presidential election results to the Electoral College. Georgia law forbids certifying a tally that includes any ballots that were not legally cast or that were switched from Trump to Biden through the unlawful use of Dominion Democracy suite software and devices. Socialism is for figs as they allowed Republican vote watchers in all other areas, and in the bad areas we were locked out, which means 0.023% throwout rate to a 3% throwout in the rest of the state. Yeah, and that may be enough. That may be enough. Like I said, that part, I think maybe could have been flushed out a little bit better in this document, but I mean, it is there. It says that this specific county did these practices that made it different. And that part I think is good. The other parts of the section, I have concerns. Like I said, we won't know until the judge rules, but I'm pointing out my concerns. Alternatively, plaintiffs seek declaratory and injunctive relief holding that the election under these circumstances was improperly certified. The governor be required to recertify the results, declaring that Donald Trump has won the election, transmitting Georgia's certified presidential election result in favor of President Trump. Bold. Plaintiffs have no adequate remedy at law and will suffer serious and irreparable harm unless the declaratory and injunctive relief requested herein is granted. Indeed, the setting aside of an election in which the people have chosen their representative is a drastic remedy that should not be undertaken lightly, but instead should be reserved for cases in which a person challenging an election has clearly established a violation of election procedures and has demonstrated that the violation has placed the result of the election in doubt. Georgia law allows elections to be contested through litigation, both as a check on the integrity of the election process and as a means of ensuring the fundamental right of citizens to vote and have their votes counted accurately. Whoa, hey! What's up, Amazing Lucas? The Amazing Lucas says, much respect, my guy. I fell asleep reading it, and District of Georgia didn't really give me much faith. If they pull this off, we're popping bottles first round on me. Absolutely, man. That would be great. Hey, we got to chat anyway. With the typos, I'm normally a real dick about typos and lawsuits because I'm reading them, but I will say they happen quite frequently, and this was probably typed up very, very hastily, and they've done a pretty decent job overall. It is really embarrassing to have a typo in your caption, but in the end, that won't have any real effect. But we'll see, man. We'll see if they do pull this off. Yeah, I'm game. Second round on me. All right. In addition to the alternative request for relief in the preceding paragraphs hereby restated, plaintiffs seek a permanent injunction requiring the county election boards to invalidate ballots cast by 1. Voters whose signatures on their registrations have not been matched with ballot, envelope, and voter registration check, all dead votes, damn, and all 900 military ballots in Fulton County that supposedly were 100% for Joe Biden. Oh. So every military ballot in Fulton County was for Joe Biden? That doesn't sound, that doesn't sound great. That doesn't sound great at all. See, this should have been in the facts section, and this should have been the facts section too. They didn't really elaborate on the dead votes or this military ballots in Fulton County. Maybe it might be in someone's affidavit, and then that could be okay. But they didn't. I didn't see them in the facts section, so they should be in there. But technically they're not alleging that this happened. Well, this one they kind of are. That's crazy though. Count 3, equal protection, denial of due process, disparate treatment of absentee and mail-in voters among different counties. What are dead votes in quotation marks? I would imagine that they're votes from people who are deceased. Although Raffensperger, I saw him on a press conference say that the 4 reported deceased people in Georgia were not actually deceased. That doesn't mean anything. That's just what I saw. Okay? I just wanted to put that out there. He said that the 4 that were reported were not actually deceased. I think it was more than 4. I know in like Michigan and Pennsylvania there were many more than 4, but they did some research on like 4 of them and found that they were not. They say. I'm just reporting what he said. I don't have any reason to believe him. Voting is a fundamental right protected by the 14th Amendment to the U.S. Constitution. 14th Amendment protects the right to vote from conduct by state officials which seriously undermines the fundamental fairness of the electoral process. Having Marks v. Stinson, having once granted the right to vote on equal terms, the state may not, by later arbitrary and disparate treatment, value one person's vote over that of another, citing Bush. Defendants are not part of the General Assembly, cannot exercise legislative power. Rather, defendants' power is limited to executing the laws as passed by the legislature. Although the Georgia General Assembly may enact laws governing the conduct of elections, no legislative enactment may contravene the requirements of the Georgia or U.S. constitutions. Federal courts, quote, possess broad discretion to fashion an equitable remedy, citing Castle v. Sangamo West, and the decision whether to grant equitable relief, and if granted, what form it shall take lies in the discretion of the district court. Okay, so you have 2 things in law. You have the legal remedy. You do have equitable remedies. Equitable remedies are not a full legal remedy. It's like getting partway there in the interest of justice. So you have remedies at law and remedies at equity. Moreover, to the extent that a voter is at risk for having his or her ballot rejected due to minor errors made in contravention of those requirements, the decision to provide a notice and opportunity to cure procedure to alleviate that risk is one best suited for the legislature, particularly in light of the open policy questions attendant to that decision, including what the precise contours of the procedure would be, how the concomitant burdens would be addressed, and how the procedure would impact the confidentiality and counting of ballots, all of which are best left to the legislative branch of Georgia's government. The disparate treatment of Georgia voters is in subjecting one class of voters to greater burdens on or scrutiny than another violates equal protection guarantees because, quote, the right of suffrage can be denied by a debasement or dilution of the weight of a citizen's vote just as effectively as by wholly prohibiting the free exercise of the franchise. Defendants are not the legislature, and their unilateral decision to create and implement a cure procedure for some but not all absentee and mail-in voters in this state violates the Due Process Clause of the United States Constitution. Plaintiffs have no adequate remedy at law and will suffer serious and irreparable harm unless the injunctive relief requested herein is granted. Okay. So they're saying that just This is similar to the Pennsylvania case, it seems. There was a cure procedure for some, but not all absentee and mail-in voters. In Pennsylvania, they got shot down because that was a permissive process where it allowed them to create a cure because it was more permissive and not more restrictive, even though that cure wasn't available to everyone. But that was done. That might be different there because in Pennsylvania, presumably every county could have done it, just some elected not to. I'm not sure how this played out here in Georgia. If it played out the same way in Pennsylvania, this probably won't be heard. But if it played out in a different way, if where just this county created a notice an opportunity to cure, and implemented it on their own, and not that every county could have done it, but some decided not to. Those are different things, right? If every county can create it, or if every county can do it, like the Secretary of State says, hey, everybody, you can make this notice and opportunity to cure thing, go get them, and then 3 counties do and 3 counties don't, that's not an equal protection violation because the counties could have done it. That's just a political or administrative decision by the counties, and it doesn't remove anyone's ability to cast a vote properly. In this one, if they created notice to cure procedure in just one county, it may be. But the problem with this is it doesn't actually do anything to prevent someone from voting. Does that make sense? So, the problem with this argument, and I'm not saying this is fatal. It was fatal in Pennsylvania. It may be fatal here. It may not. The problem with this argument is that even if they unlawfully expanded a notice and cure operation in one county and no other counties, that doesn't stop anyone from actually voting in any county. In any of them. Doesn't actually prevent the exercise of the right. It just offers some people an opportunity to cure. But they don't have a right to an opportunity to cure. So you're not granting a right to someone and then taking it away from someone else. So that speaks against equal protection. Now, maybe they'll have better luck than they did in Pennsylvania. Again, just pointing out, it's my job to point out concerns. Count 4. 14th Amendment. So Elections and Electors Clause, denial of due process on the right to vote. I'm trying not to doom pill that guy, Mitch. But there is no doom pill free zone tonight. Denial of due process on the right to vote. The right of qualified citizens to vote in a state election involving federal candidates is recognized as a fundamental right under the 14th Amendment of the U.S. Constitution. The right of all qualified citizens to vote in state as well as federal elections. Indeed, ever since the Slaughterhouse cases, U.S. Supreme Court has held that privileges or immunities clause of the 14th Amendment protects certain rights of federal citizenship from state interference, including the right of citizens to directly elect members of Congress. Okay. Bad Vibe says, wait, soldiers voting for a guy sending them to die, take their weapons, and destroy their freedom of speech? Press X. The fundamental right to vote protected by the 14th Amendment is cherished in our nation because it, quote, is preservative of other basic civil and political rights. Voters have a, quote, right to cast a ballot in an election free from the taint of intimidation and fraud. And confidence in the integrity of our electoral process is essential to the functioning of our participatory democracy. Obviously included within the right to vote, secured by the Constitution, is the right of qualified voters within a state to cast their ballots and have them counted if they are validly cast. The right to have the vote counted means counted at full value without dilution or discount. Every game played says, for notice and cure issue, wouldn't the argument be that if a defective ballot is unlawfully cured, then the ballot should be rethrown out instead? Maybe. Maybe. But it's hard to have an unlawful cure. It's typically, you're allowed to be more permissive with rights. It's a tough one. It's a tough one. I don't know. So the cured ballot should be thrown out. Well, no. No, because they're saying that the damaged parties are the ones that did not have the opportunity to have their ballots cured, while someone else did. So then the remedy would be to grant the right, if it is a right, to the people who did not receive it, not take away the right if it is a right from the person who got it. So the remedy would be to allow people who were rejected to have an opportunity to cure. The problem with this, that is, if it's not a right, and therefore you want to go the other way, if it's not a right, then it's not an equal protection issue at all. Every voter in a federal election, whether he votes for a candidate with little chance of winning or for one with little chance of losing, has a right under the Constitution to have his vote fairly counted without it being distorted by fraudulently cast votes. Invalid or fraudulent votes debase and dilute the weight of each validly cast vote. The right to an honest count is a right possessed by each voting elector, and to the extent that the importance of his vote is nullified, wholly or in part, he has been injured in the free exercise of a right or privilege secured to him by the laws of the Constitution of the U.S. Practices that promote the casting of illegal or unreliable ballots or fail to contain basic minimum guarantees against such conduct can violate the 14th Amendment by leading to the dilution of validly cast ballots. The right of suffrage can be denied by a debasement or dilution of the weight of a citizen's vote just as effectively as by wholly prohibiting the free exercise of the franchise. In Georgia, the signature verification requirement is a dead letter. The signature rejection rate for the most recent election announced by the Secretary of State was 0.15%. Signature rejection rate for absentee ballot applications was 0.00167%, only 30 statewide. Hancock County, Georgia, population 8,348, rejected 9 absentee ballot applications for signature mismatch. Fulton County rejected 8. That's a big difference, right? Population 8,000, population what, like 800,000 to a million? No other metropolitan county in Georgia rejected even a single absentee ballot application for signature mismatch. State of Colorado, which has run voting by mail for a number of years, has a signature rejection rate of between 0.52 and 0.66%. State of Oregon had a rejection rate of 0.86 in 2016. State of Washington has a rejection rate between 1 and 2%. If Georgia rejected absentee ballots at a rate of 0.52% instead of the actual 0.15%, approximately 4,600 more absentee ballots would have been rejected. Okay. I'm not sure what that had to do with dilution. I guess they're saying that the casting of these 4,600 fraudulent votes, that dilutes or diminishes. That's a hard sell. That's a hard sell. There was widespread ballot fraud. Okay, this is what I'm hoping to see. Bad Vibe says, so if a rule for curing being changed from allowed to must cure, would that change the perspective of the judge? Maybe. Maybe. The judge might just disagree with the Pennsylvania judge, too. That's possible. Plaintiffs referred to and incorporate by reference each of the prior paragraphs of this complaint. Yeah. Plaintiffs contest the results of Georgia's election with standing conferred under pursuant to OGCA 21-521. Therefore, pursuant to the law, for misconduct, fraud, or irregularity by any primary or election official or officials sufficient to change or place in doubt the result, the foundational principle that Georgia law, quote, nonetheless allows elections to be contested through litigation, both as a check on the integrity of the election process and as a means of ensuring the fundamental right of citizens to vote and have their votes counted accurately. The Georgia Supreme Court has made clear that plaintiffs need not show how the voters would have voted if their ballots had been regular, only had to show that there were enough irregular ballots to place in doubt the result. The Supreme Court invalidated an election, ordered a new election because it found that, by the way, I'm liking this one better already. because they have standing conferred to them with a specific cause of action under Georgia law. It's impacting a federal election. So under Bush v. Gore, it seems that that would go to the federal courts. So I'm liking this better because this section, they appear to have standing. So that's a good start. Let's see. Meade versus Sheffield. The Supreme Court invalidated an election and ordered a new election because it found that, quote, thus it was not incumbent upon the plaintiffs to show how the 481 voters would have voted if their absentee ballots had been regular. He only had to show that there were enough irregular ballots to place in doubt the result. He succeeded in that task. Citing Howell versus Fears, primary results invalid where ballot in one precinct omitted names of both qualified candidates. The glitches in the Dominion system that seem to have the uniform effect of hurting Trump and helping Biden have been widely reported in the press and confirmed by the analysis of independent experts. Real quick, since I forgot to mention it just a second ago, they likely cannot order a new election of a president, and that is why they haven't asked for a re-election of the president. They have asked for the remedy of either refusing to certify or certifying on behalf of Trump, because that would be the appropriate remedy. The Constitution would prohibit a revote. The glitches in the Dominion system that seem to have the uniform effect of hurting Trump and helping Biden have been widely reported in the press and confirmed by the analysis of independent experts. Prima facie evidence in multiple affidavits shows specific fraudulent acts which directly resulted in the flipping of the race at issue. Votes being switched in Biden's favor away from Trump during the recount. The lack of procedures in place to follow the election code and the purchase and use Dominion voting systems despite evidence of serious vulnerabilities. A demonstration that misrepresentations were made about a pipe burst that sent everyone home, while first 6, then 3 unknown individuals were left alone until the morning hours working on the machines. Further, a failure to demonstrate compliance with the Georgia's election codes in maintenance logs on the voting systems for a genuine and sound audit, other than voluntary editable logs that prevent genuine audits. While the bedrock of this democratic republic rests on citizens' confidence in the validity of our elections and a transparent process, Georgia's November 3rd general election remains under a pall of corruption and irregularity that reflects a pattern of the absence of mistake. At best, the evidence so far shows ignorance of the truth. At worst, it proves a knowing intent to defraud. Doc Shock, the exhibits aren't in the document. They're not available. Plaintiff's expert also finds that voters received tens of thousands of ballots that they never requested. Or they might be available now. Specifically, Dr. Briggs found that in the state of Georgia, based on a statistically significant sample, the expected amount of persons that received an absentee ballot, blah, blah, blah. Okay, the 17 to 23,000. The widespread pattern, as reflected within the population of unreturned ballots analyzed by Dr. Briggs, reveals the unavoidable reality that in addition to the calculations herein, third parties voted an untold number of unlawfully acquired ballots, which would not be in the database. Okay. Further, there exists clear evidence of the absentee or whatever voters that moved. So the plaintiff's expert, Russell Ramsland, concludes that at least 96,600 mail-in ballots were fraudulently cast. He further concludes that up to 136,098 ballots were illegally counted as a result of improper manipulation of the Dominion software. Socialism is for figs says, so if Bush v. Gore made a new standing, why can't this one be a new standing as well? Why do you keep saying there's no standing when it can be created? And you do realize they threw 80 million ballots into the mail. I'm pointing out the standing argument that the federal judge in Georgia already used. So why am I arguing it? It's because the existing judge in the close to the same jurisdiction, if not the same jurisdiction, used that standing ruling. That's what I'm saying. Bush v. Gore is also a very different issue than what's been going on in these elections. It was not the same issue. Rudy Giuliani said it was the same issue. It's not the same thing. In Bush v. Gore, you had the Florida Supreme Court had the authority over the elections and how they were being done, and they applied them unequally. That created an equal protection issue in Florida. You had one governing body telling specific counties to do something different. That's how they got to the equal protection issue in Florida. I don't know about their standing argument. It doesn't really matter. I'm, again, reporting what was said by the Georgia federal judge in the Linwood case. But like I said, this section is way better than that one. And having the counts separated out means that if a particular count, if they lack standing to bring that claim, it's just that claim. Like, it's not going to knock out the whole lawsuit. The first cause of action was good. This cause of action looks good. I think the previous cause of action I thought looked good too. Why is the judge using Bush v. Gore as standing if it's not the same issue? This isn't the judge. This is an attorney. Okay. Why are you saying I'm a commie? Oh my goodness. The very existence of absentee mail-in ballots created a heightened opportunity for fraud. The population of unreturned ballots analyzed by William Briggs reveals the probability that a far greater number of mail ballots were requested by third parties or sent erroneously to persons who voted fraudulently, undetected by a failed system of signature verification. The recipients may have voted in the name of another person, may have not had the legal right to vote and voted anyway, or may not have received the ballot at the proper address and then found that they were unable to vote at the polls except provisionally due to a ballot outstanding in their name. When we consider the harm of these uncounted votes and ballots not ordered by the voters themselves, and the potential that many of these unordered ballots may in fact have been improperly voted and also prevented proper voting at the polls, the mail ballot system has clearly failed in the state of Georgia and did so on a large scale and widespread basis. The size of the voting failures, whether accidental or intentional, are multiples larger than the margin of votes between the presidential candidates and the state. For these reasons, Georgia cannot reasonably rely on the results of the mail vote. The right to vote includes not just the right to cast a ballot, but also the right to have it fairly counted if it is legally cast. The right to vote is infringed if a vote is canceled or diluted by a fraudulent or illegal vote, including without limitation when a single person votes multiple times. Supreme Court of the United States has made this clear in case after case. Gray versus Sanders. Every vote must be protected from the diluting effect of illegal ballots. Crawford versus Marion County Election Board. There's no question about the legitimacy or importance of the state's interest in counting only the votes of eligible voters. And in accord, Reynolds v. Sims. Plaintiffs have no adequate remedy at law, as seen from the expert analysis of William Higgs, PhD, based on actual voter data. Tens of thousands of votes did not count, and tens of thousands of votes were unlawfully requested. 14th Amendment Due Process Clause protects the right. Now, this isn't equal protection. This is due process. So there, we got a different question here, and that's fine. Like I said, this section's good anyway. They have statutory authority to bring this, and that is, I think this is a good section. Vote Commie Nick. Replaced with conservative Chair Coon. Oh my goodness. Protects the right to vote from conduct by state officials which seriously undermines the fundamental fairness of the electoral process. Oh, this has a link? This one doesn't. Weird. Separate from the Equal Protection Clause, the 14th Amendment's Due Process Clause protects the fundamental right to vote against the disenfranchisement of a state electorate. When an election process reaches the point of patent and fraud and fundamental unfairness, there is a due process violation. If the election process itself reaches the point of patent and fundamental unfairness, a violation of due process clause may be indicated in relief under 1983, therefore an order. Enjoining winning state Senate candidate from exercising official authority where absentee ballots were obtained and cast illegally. So this is a good section. I like it. Part of the court's justification for such a ruling is the Supreme Court's recognition that the right to vote and to free and fair elections is one that is preservative of other basic civil and political rights. Since the right to exercise the franchise in a free and unimpaired manner is preservative of other basic civil and political rights, any alleged infringement of the right of citizens to vote must be carefully and meticulously scrutinized. The political franchise of voting is regarded as fundamental political right because preservative of all rights. Woo! The right to vote, the right to have one's vote counted, and the right to have one's vote given equal weight are basic fundamental constitutional rights incorporated in the Due Process Clause of the 14th Amendment to the Constitution of the United States. A state law that allows local election officials to impose different voting schemes upon some portions of the electorate and not others violates due process. Just as the Equal Protection Clause of the 14th Amendment prohibits state officials from improperly diluting the right to vote, the Due Process Clause of the 14th Amendment forbids state officials from unlawfully eliminating that fundamental right. Having once granted the right to vote on equal terms, defendants may not, by later arbitrary and disparate treatment, value one person's vote over that of another. In statewide and federal elections conducted in the state of Georgia, including without limitation November 3rd general election, all candidates, political parties, and voters, including without limitation plaintiffs, have vested interest in being present and having meaningful access to observe and monitor the electoral process to ensure that it is properly administered in every election district and otherwise free, fair, and transparent. Moreover, through its provisions involving watchers and representatives, the Georgia Election Code ensures that all candidates and political parties, including without limitation plaintiff Republicans and the Trump campaign, shall be present and have meaningful access to observe and monitor the electoral process to ensure that it is properly administered in every election district and otherwise free, fair, and transparent. Oh my God! I need more lubricant. Defendants have a duty to guard against deprivation of the right to vote through the dilution of validly cast ballots by ballot fraud or election tampering. Rather than heeding these mandates and duties, defendants arbitrarily and capriciously denied the Trump campaign and Republicans meaningful access to observe and monitor the electoral process by A, mandating that representatives at the pre-canvass and canvass of all absentee and mail-in ballots be either Georgia barred attorneys or qualified registered electors of the county in which they sought to observe and monitor. And B, not allowing watchers and representatives to visibly see and review all envelopes containing official absentee and mail-in ballots either at the time or before they were opened and or when such ballots were counted and recorded. Instead, defendants refused to credential all of the Trump campaign's submitted watchers and representatives and or kept Trump's campaign watchers and representatives by security and metal barricades from the areas where the inspection, opening, and counting of absentee and mail-in ballots were taking place. The lack of meaningful access with actual access to see the ballots invited further fraud and cast doubt on the validity of the proceedings. Consequently, defendants created a system whereby it was physically impossible for the candidates and political parties to view the ballots and verify that illegally cast ballots were not opened and counted. Defendants intentionally and or arbitrarily and capriciously denied plaintiffs access to and or obstructed actual observation and monitoring of the absentee and mail-in ballots being pre-canvassed and canvassed by the defendants, and included the unlawfully not counting and including uncounted mail ballots, and that they failed to follow absentee ballot requirements when thousands of voters received ballots that they never requested. Defendants have, and I've talked to someone recently who is in one state and witnessed someone admit that ballots were sent out to people who didn't request them. It was great. Defendants have acted and will continue to act under color of state law to violate the right to vote and due process as secured by the 14th Amendment to the U.S. Constitution. Plaintiffs have no adequate remedy at law, blah, blah, blah. And we consider the harm of these uncounted votes and ballots not ordered by the voters themselves and the potential that many of these unordered ballots may in fact have been improperly voted and also prevented proper voting at the polls. The mail ballot system has clearly failed in the state of Georgia. Did so on a large scale and widespread basis. The size of the voting failures, whether accidental or intentional, are multiples larger than the margin of the state. For these reasons, Georgia cannot reasonably rely on the election results of the mail-in vote. Relief sought is the elimination of the mail ballots from counting in the 2020 election. Alternatively, the presidential electors for the state of Georgia should be disqualified from counting toward the 2020 election. So there you go. They've asked to remove all mail-in votes, or in the alternative, not allow the selected electors. U.S. Code provides that if any state shall have provided by laws enacted prior to the day fixed for the appointment of the electors, or its final determination of any controversy or contest concerning the appointment of all or any of the electors in such state by judicial or other methods or procedures, and such determination shall have been made at least 6 days before the time fixed for the meeting of the electors, such determination made pursuant to such law so existing on said day, and made at least 6 days prior to said time of meeting of the electors, shall be conclusive and shall govern in the counting of the electoral votes as provided in the Constitution and as hereinafter regulated, so far as the ascertainment of the electors appointed by such state is concerned. Woo! Woo! That got thick. That one got very thick. But it's one of their better claims. It's why they put it last. You tend to sandwich the crap in between good things. I know their first one was pretty decent. The last one was very good. The ones in the middle, kind of sus. Quest for relief. Accordingly, plaintiffs may seek an emergency order instructing defendants to decertify the results of the general election for the office of president. In the alternative, plaintiffs seek an emergency order prohibiting defendants from including in any certified results from the general election tabulation of absentee and mailing ballots which do not comply with the election code, including without limitation the tabulation of absentee and mail-in ballots Trump campaign's watchers were prevented from observing, or based on the tabulation of invalidly cast absentee and mail-in ballots, which, one, lack a secrecy envelope, or contain on that envelope any text, mark, or symbol which reveals the elector's identity, political affiliation, or candidate preference. 2, do not include on the outside envelope a completed declaration that is dated and signed by the elector. Or 3, are delivered in person by third parties for non-disabled voters. When we consider the harm of these uncounted votes and ballots not ordered by the voters themselves and the potential that many of these unordered ballots may have in fact been improperly voted and also prevented proper voting at the polls, the mail ballot system has clearly failed in the state of Georgia. We've read this about 8 times. And did so on a large scale and widespread basis. The size of the voting failures, whether accidental or intentional, are multiples larger than the margin in the state. For these reasons, Georgia cannot reasonably rely on the results of the mail vote. Relief sought is the elimination of the mail ballots from counting in the 2020 election. Alternatively, the electors for the state of Georgia should be disqualified from counting toward the 2020 election. Alternatively, the electors of the state of Georgia should be directed to vote for President Donald Trump. For these reasons, plaintiffs asks this court to enter judgment in their favor and provide the following emergency relief. An order directing Governor Kemp, Secretary Raffensperger, and the Georgia State Board of Elections to decertify the results. An order enjoining them from transmitting the currently certified results to the Electoral College. An order requiring Kemp to transmit certified election results that state that President Donald Trump is the winner of the election. An immediate order to impound all the voting machines and software in Georgia for expert inspection by the plaintiffs. An order that no votes received or tabulated by machines that were not certified as required by federal law and state law be counted. Declaratory judgment declaring that Georgia Secretary of State rule violates the Electors and Elections Clause. Declaratory judgment declaring that the Georgia's failed system of signature verification violates the Electors and Elections Clause by working a de facto abolition of the signature verification requirement. Declaratory judgment declaring that the current certified election results violates due process. Declaratory judgment declaring that the mail-in absentee ballot fraud must be remedied with a full manual recount or statistically valid sampling that properly verifies the signatures on absentee ballot envelopes and that invalidates the certified results if the recount or sampling analysis shows a sufficient number of ineligible absentee ballots were counted. An emergency declaratory judgment that voting machines be seized and impounded immediately for a forensic audit by plaintiff's experts. That was already set up here. Declaratory judgment declaring absentee ballot fraud occurred in violation of constitutional rights, election laws, and under state law. Permanent injunction prohibiting the governor and secretary of state from transmitting the currently certified results to the Electoral College based on the overwhelming evidence of election tampering. Immediate production of 36 hours of security camera footage recording all rooms used in the voting process at State Farm Arena in Fulton County, Georgia, from 12 a.m. to 3 a.m. until 6 p.m. That's weird. On November 3rd. Plaintiffs further request that the court grant such other relief as is just and proper, including but not limited to the cost of this action, their reasonable attorney's fees, and expenses pursuant to 42 USC 1988. Respectfully submitted this 25th day of November 2020 by Harry McDougald and Sidney Powell. We did it, Reddit. We did it. Notice how long I'm scrolling? 104 pages, baby. Oh, I am spent. Lin Wood can be on there all day. I wouldn't put him on there. Oh my goodness. Okay. Send me the Michigan one if I want to read it. Not right now, I don't. Right now, I don't want to read anything ever again, ever. I've decided to give up reading for the rest of my life. Ugh. All right. So, some compelling stuff here. Compelling narrative. Yeah, I know. Sean Parnell's suit. I might have to go full in on Sean Parnell's suit tomorrow. Cause that's right here, by the way. It's only 24 pages. Wish I would have picked that one. Let me talk about this, though. We've got compelling story. We've got good plaintiffs. Much better plaintiffs than just Lin Wood. Lin Wood had a bad theory. Again, I'm really annoyed that I didn't realize he was filing on behalf of himself the first time I looked at it. Because he had some interesting and good stuff in there, but he didn't have a good theory as to why he should be able to bring a case in federal court. Maybe in Georgia state court, but that's not where he was. He was in federal court. This one, on the other hand, these are all proposed electors. Therefore, they seem to have standing conferred to them, at least in the one specific Georgia state claim. However, it is a Georgia state claim impacting a federal election, making the federal court have jurisdiction, which is good. But they also appear to have standing under that law, which is good as well. Some of the allegations of vote dilution are problematic for the same reason that Lin Wood's case got tossed. We'll have to see if they're sufficiently different from Lin Wood's case to merit them staying. We'll have to see. Don't know. But yeah. As to the causes of action, I thought the first one was good. I think I said. I'm going to just read the subheadings. Count 1. Disparate treatment. Wait, that's count 3. Oh my God. They go back this far? Where was count 1? Defendants violated the elections clause. Yeah, okay, so by creating a rule, the cure procedure, they violated the electors and elections clause because they're not allowed to do it. I agree. I agree with that. They shouldn't be allowed to create a cure procedure. That is something that should be done by law, and it may violate the electors and elections clause. Count 2 was the equal protection, and this one was more of a problem for me. Count 3 was what? Disparate treatment of absentee and mail-in voters among different counties. This one I think I like this one a little bit better. Count 4 was denial of due process on the right to vote. This one was, I think this was the good one. No, count 5. This was the really good one. This one, the due process violation, we've got the numbers. This is where, in Hancock County, they had, Hancock versus Fulton. This is a tough one. Count 5 was great. Widespread ballot fraud. Again, I think this count, and you can notice by the length of it, it's pages and pages long. They knew this is the bulk of their claim, in my opinion. This is the main thrust of it, and that is the most important part. Count 5. We could have just read count 5, I think. That would have been more fun than reading the entire suit. They have a lot of stuff in this suit that's not necessary. I mean, sure, it tells a fun story about Dominion, but they never really link. Okay, I just want to point out, there's an entire section of this lawsuit, which is pages long, talking about Dominion software being abused in Venezuela. And none of that comes out in the counts, in the actual allegations later on. It's just a backdrop in a way to allege fraud without bringing it up. In my opinion, that is some sloppy legal work. I don't know if they meant to flush that out in a count better. Even so, even if Dominion comes out and says, yeah, we defrauded the Venezuelan elections, piss off. That doesn't mean anything about this election. So, I mean, it doesn't hurt the case in any way. It doesn't hurt it. I mean, they do bring up that there was unsecured stuff with the balloting machines that's in there somewhere. It doesn't hurt it. It just added length that I didn't think needed to be there. So it's just a criticism I have, because it just doesn't. All of the stuff they said about Dominion in Venezuela doesn't have any impact on today. Even the stuff they said about Venezuela in 2019 doesn't have any impact on today. Doesn't legally have impact on today. Logically, does it? Yes. Yes. Sorry. I should be clear on this, because I know I speak very colloquially about things and very conversationally. Yes. Logically, if Dominion is a bastion for fraud, the fact that they chose Dominion to possibly implement fraud is not weird at all. It's probably what happened. Okay? Logically. Legally, logic goes out the window, and we have to get to, yeah, but did they though? Okay, so they did all this fraud before, but did they now? Well, it seems like they did. I mean, sure, it seems like they did, but did they? So, that's the question the court's going to have to ask. So, I'm not a big fan of that Dominion section. I think it's just a waste of pages, personally. All right, let's same machines and same software. Yeah, but no vote showed up for Hugo Chavez. We're not going to read this case. Woo! We're not going to read this case. Instead, what I'm going to do, we're not going to read it tonight. Instead, what I'm going to do is I'm going to preview for you the complex constitutional of Pennsylvania question that's raised in this case and why this case is so interesting. Okay? All right. I'm not going to read the case. I've already read the case to myself. I'm not going to read it with you tonight. I'll flush this out more thoroughly tomorrow, but after today, I can't do another full stream, or I can't keep this stream going much longer. We're already at 2 hours and 10 minutes. All right. So here's the complex constitutional question. So, in Pennsylvania, under the Pennsylvania Constitution, there are 4 recognized exceptions. There are 4 recognized exceptions to the in-person voting requirement. Okay? So the Pennsylvania Constitution requires you to vote in person, but it does recognize 4 exceptions to that, allowing for absentee or mail-in ballots. All right? Now, back in 2019, way back, the Republicans in Pennsylvania proposed a bill to create no excuse mail-in balloting. Why Republicans in Pennsylvania wanted to push through no excuse mail-in balloting, which means no requirements, no exception requirements, just that everybody could vote by mail-in ballot. Why Republicans chose to do this is beyond me. I have no idea. Not rhinos. I mean, well, unless every Republican legislator in Pennsylvania is a rhino. I mean, if you're saying that, fine. But it was basically all of them. And I find that hard to believe, but maybe it was. So anyway, and this is in 2019. This is before Corona-chan. This is not. Anyway, so they decide no excuse mail-in ballots are good. However, the Pennsylvania Constitution has the only exception. So to create no excuse mail-in ballots, you have to amend the Pennsylvania Constitution, okay? Does that make sense? You have to amend the Constitution of Pennsylvania to change the mail-in or absentee ballot exception requirement. So, they intend to do that. How do you pass a constitutional amendment in Pennsylvania? All right. You have to vote on it in one session of Congress, which they did, and it passed overwhelmingly. But then you have to vote on it in a second session of Congress, a separate session. So the next year, Congress has to vote on the bill again. Now, between that happening, so they do the first vote. It has to be published in 2 newspapers in every county that has newspapers. That the results and all this stuff have to be published. And then they go to the second session of Congress, which would be the next year's session. And then that session of Congress has to vote again to approve it. Okay? And then it has to get published in the newspapers again. And then what they have to do after that is they have to put the constitutional amendment to a general ballot measure. All right? So they have to put it to a general ballot measure, and then the people have to vote on it to actually change the Constitution by an amendment. So, legislative session 1, legislative session 2, and then the people have to vote. And there's some time requirement before a current year election that it has to happen. Importantly, it never went to a ballot, and I believe it's only been passed in one session of Congress. Yes, this is for Pennsylvania, Maya. So, there is a possible alternative. And that would be if there's an emergency requirement to amend the Constitution, they only have one session of Congress, passing it as an emergency measure. There's still the publication requirement in the newspapers, and there's still the balloting requirement, none of which occurred. So, the issue at play here is it appears that though Pennsylvania attempted to make mail-in balloting legal without excuse in 2019, that they couldn't because they didn't amend the Constitution. That it wasn't a successful it was a successful passage of the bill. However, they would still need a second vote and then the ballot measure to happen before they could properly amend the Constitution to allow for the creation of no excuse absentee balloting. And that is what the lawsuit is primarily about. Now, there's some issues with this. There's an issue with this, okay? They didn't do it. It didn't happen. You're all right. However, they did it. They also did it. And by did it, I mean they passed the bill and they allowed absentee voting with no excuses. Not only in this election, but in the previous election. The 2019 election. The one for the state legislature. Okay? If this is unconstitutional and they take it back to the logical conclusion, the state legislature doesn't exist. Dr. OPM, I'm using the colloquial version of absentee, mail-in and absentee, just not in-person voting. So, because those elections allowed, the one last year allowed mail-in voting, the House of Representatives of Pennsylvania, has the potential to not exist. Now, it's not that simple because maybe the number of absentee ballots cast or mail-in ballots cast in 2019 wasn't sufficient in any particular race to call the race into question, right? We've been talking about that a lot in Georgia, and that are there sufficient number of votes to call the race into question? If there aren't, then we don't really have a controversy because it's not going to change the outcome. If we do, then we might have a question. So, the Pennsylvania courts are stuck with a conundrum. This law and the absentee voting scheme is plainly unconstitutional. It is. It is unconstitutional. However, they've had now 2 votes and 1 certified election for sure in 2019 that have taken place with this scheme. A weird sort of question is it too late? All right. Now, there is no statute of limitations on the Constitution, so it's never too late to find something unconstitutional. And that's not what I'm talking about. I'm talking about, is the remedy too late? This is what the court will be considering. Did Republicans forfeit their right to remedy by not bringing this sooner to the remedy they're asking for, which is the decertification of the election. I say the Constitution is the Constitution and that they should be decertified. I don't think we have to answer the question of whether the legislature elected in 2019 needs to be decertified. I don't think we do. Because I think that the challenge period for this election is still open, whereas the challenge period for that election may be closed. So I don't, even if they had basically an unlawful voting scheme, and this happens all the time. If you have unlawful votes or even an unlawful voting scheme or whatever, and an election takes place, and you don't challenge it in the appropriate amount of time, well then, at some point you just have to deal with the fact that it happened. You can get a declaratory relief that it was wrong, but then the political process has occurred. We're at the presidential election. There's no reason for results to be certified at this point, and the electors have not cast their votes. We're in the challenge period. So, in my opinion, they should be able to strike down either the entirety of the votes or the absentee votes without, it'll be an issue, but they should be able to do it. Under the Constitution, that's what should happen. This voting scheme was illegal, but the results are not official and have not had impact yet. They've not been perfected. So therefore, stop them. So, that's my opinion. Now, Pennsylvania judge is going to look at this and go, or the Pennsylvania Supreme Court, as it were, which people have aptly pointed out is 5-2 Democrat to Republican. And unfortunately, this is a state law issue. This probably cannot go to the United States Supreme Court. It does impact federal elections, so maybe they could get it in that way. Maybe they would have standing or appellate review. Here's how this one has to go. This one has to get appealed to the Pennsylvania Supreme Court, and then they would have to ask the U.S. Supreme Court to review the Pennsylvania Supreme Court's decision on the Pennsylvania Constitution, which is a very, very tall order. However, they might be able to do it because the question of a federal election may be enough of a federal question, again, citing Bush v. Gore, to establish standing when deviation from a rule impacts a federal election. Maybe. It's a hard sell. It's a very hard sell. This is the Pennsylvania Constitution, and presumably matters of Pennsylvania Constitution would be limited to Pennsylvania Supreme Court. So we'll have to see how this goes. But in any case, the judge has to say, we told these people they can vote, and now we're not going to count their vote. And therefore, we've taken away not only this vote, but their opportunity to have voted properly. And I know it seems really academic and simple for us to sit here and say, well, but these are the rules. That's what should happen. And I get there. I'm also a cold bastard. I get there and say that the Constitution is the law. They have not amended the law. Therefore, the procedures that they adopted must not be allowed to have occurred. Simple. But I'm not the person making the decision over like 2 million voters and invalidating 2 million people's rights. That's a lot. That's a lot of rights being violated. And when you look at it from a judge's perspective, that's a tough sell. Will they do it? I don't know. If they do it and it goes up to the U.S. Supreme Court, will they undo it? I don't know. It's tough. It's very tough. So these are the issues at play in the Commonwealth Court of Pennsylvania regarding this. This is a very interesting lawsuit. A very interesting lawsuit because it's a constitutional issue. It appears to be clear. Like, there isn't an exception to amending the Constitution, and they just didn't do it. They all treated it like they did. The governor, the courts, the legislature. Hell, even my Westlaw research documentation lists the changes to the Constitution of Pennsylvania. It lists them as amended in Westlaw. People think it was changed. Socialism is for Fig says, are you a judge? No. Are you a Constitution expert? I mean, somewhat. Or did you quit your practice for YouTube because of failure? No. Not at all. I quit my practice for YouTube. Actually, I didn't quit my practice. I have a fucking case in 4 days. It wasn't because of failure. This is more fun to do. You are a doomer, and I will never forgive that. Sure. Okay. Whatever you want, pal. That's okay. You don't have to forgive me. If I end up being right, then you'll know. But I'm saying I don't know what the judges will do in this case. Like I said, the rule of law is clear. They didn't admit, or they didn't amend the Constitution. But everybody's treating it like it was amended. They held 2 elections now like it was amended. And I think that a Supreme Court in Pennsylvania that is 5-2 Democrat is likely to think that, well, even if it wasn't amended, we're not going to give them the remedy that they're asking for because that would be too disruptive. I think it should be the other way. But we'll see. Random 11, half of Oklahoma still. Oh my God. It's a very misunderstood headline as well. So, all right. So we'll have to see. Like I said, tomorrow we'll probably go through this. It's not super long. I wanted to lay out the real issues here. And we can skip a lot of the boring stuff and just get to the main stuff and talk about this and talk about some other stuff tomorrow, like the Senate hearing. I'm really curious about the Pennsylvania legislature hearing, which I think is promising, where the fraud is alleged in front of the Pennsylvania legislature. That is the other prong of the Trump team's attack, and Trump's team has been much more successful on the media and public perception prong of their attack than they have been on the legal prong of their attack. That's fine, by the way. That strategy may be ultimately better. The courts aren't always the proper remedy, so it's still a very long shot, but the courts are also a very long shot, so we'll have to see. In any case, they need Pennsylvania. They need 2 other states than Pennsylvania to undo the Biden lead right now. They have promising steps in Nevada going on right now, where they have depositions, and then they have a evidentiary hearing on December 2nd or 3rd. I think the 2nd. So going to be looking at the Nevada stuff and seeing what's going on over there. They've got something into a court, which is good. Getting past the first steps is actually a really big hurdle in these cases, because as I've said over and over, just bringing up these things in a court and getting them to the judge is hard to do, as evidenced by all of the failure that's been going on since Election Day. And me calling it a failure isn't a criticism. The only failure that I am criticizing is that abortion of a document turned in by Rudy Giuliani's team in Pennsylvania, where they forgot to put the fucking count in the document. That is failure, quintessentially bad. Doesn't mean that they didn't have a case, but it means that they don't now. And that is a problem, and pretending otherwise is dumb. So, that being said, their media blitz, convincing the people and possibly working on Republican legislatures to convince them that fraud happened and they need to decertify the election results, that's been working better than their court cases. And so I'm really interested to watch through that hearing in front of the legislature, or watch through segments of it. The colonel who testified to the legislature there, Twitter removed his account or whatever. They just suspended it. So there you go. Not aware of anything he said that was bad, but Twitter went after him, apparently just for testifying. Great job, them. But yeah. So that's where we are. But I really wanted to kind of lay the preliminary ground on this Pennsylvania suit, because it is a complex constitutional question without an easy answer. I mean, there's an easy answer in my opinion. I say, if it's unconstitutional, it's unconstitutional. That's the law. That's the rule. We should follow it. Unfortunately, not everybody thinks that way. So we'll have to see what they do. George Paul says, if you had to bet, were the Democrats bad little boys and girls? Should they get a coal in their stocking? Are you saying, was there election fraud? Yeah. I have no question there's election fraud. Tons of it. More and more seems to be appearing by the day. I don't know if Dominion software manipulated votes. I don't know about that. What I do know, absentee ballots are ripe for election fraud. What I do know is that this is a presidential election. It's one of the most important things that happens with votes. And with our system, it's almost impossible to get convicted for election fraud unless you're stupid. So, I also know that they regard Trump as the literal Antichrist. So when I put those things together, do I think election fraud occurred? I think it'd be lunacy to say that it didn't occur. It's too important. The numbers are too big. The cost is low, or the risk is low, and the enemy is great in their mind. So yeah, I think of course there was election fraud. My question has always been, will they be able to get the evidence of the fraud, and then will they be able to get that evidence competently before a judge? Those are two hard things to do. You can't just go into a courtroom and say, Judge, I got fraud. You have to find a plaintiff who has standing. You have to find a law or a right or a constitutional provision that was violated. And then you have to attach the fraud that you have evidence of to that thing to the court. And you have to get lucky. All of those things have to occur. It's just hard. It's not even a comment on whether, like anybody's ability. It's just a fucking hard process. So, yeah. We'll see. We'll see. All right, let's wrap up these chats, and then I am going to end the show. I will not be doing Twitch tonight. Elliot Hacker, don't worry. Well, I'll get your chat. I see it there. I will not be doing Twitch tonight. I need sleep. But I will see you guys tomorrow. So, here we go. Here are the chats. Kiwi Goes Live says, Beat Cop is $3 on Steam. It's a video game in the style of 1980s cop show and maybe the best cop game ever. I just covered Nick's copy, but the rest of you are on your own. Thank you for that. Mercenary X says, watching Mystery Science Theater 3000. Turkey Day Marathon. You and a KPBS special on Mr. Rogers. Let me tell you, Mr. Rogers is beating you both. The man was a Republican, an ordained minister, and the reason I believe in God, besides my family, I am thankful to God for him. Bless him. Morning Shift says, I still can't get over the idea that 2020 ends in the discovery of the existence of an Antifa supporter literally named Dr. Coomer. This is literally a simulation. LaPierre Hammer for prison says, each state shall appoint in such manner as the legislature thereof may direct a number of electors. Would a lawsuit seeking to invalidate mail-in ballots sent out by governors be meritorious, since the executive has no power to direct the manner? Unless the state delegated their authority to the governor, which they may be able to do, but they may not. Again, tough constitutional questions. And if anybody ever tells you that constitutional questions are clear, they never are. They never are. It depends on if the state delegated their authority. If they did delegate their authority, it depends on if the state has the ability to delegate their authority. And it then depends on if they're able to roll those things back. That is a consideration that they have to do. Can we fix it? Can we fix it? Okay. Brian Nateran says, Mr. Timmer has been confirmed the Antichrist. I agree. Find the Coleman says, hey, Nick, shill your other channel, you boomer. It's in the description. It's youtube.com/Rakeda Media. Thank you all for going over there. If you want to see nerd content that is unrelated to law, primarily, it'll be over there. Check it out. Brian Tarrant says, Mr. Timmer is a confirmed furry. Ulashed1 says, I'm thankful I didn't have to eat Nick's dry turkey. It wasn't dry. It was so good. Mario Carter 13 says, Merry Grifsmas to you too, Rackets. Thank you. A crafty Hurgok says, Happy Thanksgiving, honk the government's rules. And E-Man2 Manny says, movie suggestions to watch with Drex Tiptoes. Okay. The Shantu 3 says, bruh. Bad Vibe says, no news is better than fake news. Toast Bill Clinton says, Happy Turkey Day, bourbon drinking lawman. Hey, thanks. You too. Toast Bill Clinton says, like it up, boys. Blackwing, Winnie the, welcome to lawyer status. Winnie the Blue, welcome to paralegal. And Dex Terminax, welcome to super lawyer status. Thank you, guys. Dex Terminax, make sure you find yourself some Discord access. If you can't find it in the community tab, please message me and we'll make it happen. Gerard Garvin says, as Jay Sean Lemoyne, I'm thankful for oxygen machines, off bug spray, and con sluts. Bad Vibe says, no, Nick, you didn't already read this. Nexi says, so why is Joe giving COOF 20-1 briefings with Office of the President-elect in the background? He learned it from Obama. Lunacy and irrigation taking property by public authority in action, plus why is it tolerated? I don't know why it's tolerated, because half the country voted for him or something. I don't know. I don't believe the office of the president-elect is the most nonsensical thing I've ever seen, except for the brief period between when the electors' votes are counted and inauguration, which is like a 2-week period. Bad Vibe says, the greatest grift, getting intoxicated on tea, put in whiskey bottles. Rackets is a flyweight. CJ says, disagree about the judge discounting the statistical analysis. By your logic and law-splaining, official canvassing to certify is just polling. Look, I'm just saying, if you bring in some statistics to a judge that says, we did a statistical analysis and we determined that fraud occurred, and that's all you bring, he will throw it out. I promise. I promise. You've got to have someone witnessing it. You have to have something more. They have more in this lawsuit. They have more in this lawsuit, so that's good. But I'm just saying, you can't just say, well, statistics can be used in court. I mean, they can be, but their value. Their value. You also got to remember that the judge is a lawyer, and lawyers are bad at math, and if you bring a bunch of statistics in front of them, they won't get it. Blue Man Welder says, first time in a year I've been able to watch you live because of my new job. Hope you've been doing well. I have. I hope you've been doing well as well. Do you promise because you had stats thrown out of court in your own cases in the past? No. I'm not saying they'll throw out the stats. I'm saying if you only bring one statistical analysis into court, they'll throw out your case. It's just not going to be probative to the point on its own of saying this big issue can be resolved by this one statistical analysis. So just saying it can be admitted isn't enough. That's it. Bad Vibe says, Nick, you haven't already read this. You son of a bitch. Mario Carter 13 says, are you cracking, son? Old Blue OBS says, first time watcher on your stream. I'm hooked. Do you think this is the biblical Kraken we were promised, or is there more to come? It depends on what's in the affidavits and the exhibits. Maybe. The biblical thing was really weird. The Kraken and Kraken on steroids, weird hype talk. This is a better suit than Lynn Wood's, and I hope it's successful. We'll see, though. C. Ova says, thanks for reading this and breaking it down. Here's 5 for some Visine on those eyes. Thank you. Elliot Hacker says, were any of those judges Pennsylvania Supreme Court appointed by or determined by those 2 elections? I don't know. I have no idea. Could be a mess, couldn't it? Jamie Moodley upgraded to lawyer status. Thank you, Jamie. Welcome to it. The last time I was doom pilling, was I also drinking gin? No. Actually, most of the doom pilling this week was sober, I think, completely. But no, it's I'm not doom pilling on this one. I'm not doom pilling on either of these cases. I think the Pennsylvania case is better than the Trump campaign's cases. It's just, it's marred by this really complex constitutional question with severe implications. All of this stuff has severe implications. And courts are they are hesitant to invalidate votes. The Pennsylvania district court judge said, you're asking for the extreme remedy of invalidating 6.8 million votes. And he went on to say, you would think if you were doing that, you would bring in evidence so shocking that there would be no choice but to take this drastic measure. And instead you've brought nothing. When in fact, they had brought some stuff. Now, not very much. Admittedly, not very much. Again, I have lots of criticisms about how they handled that document, but they did have affidavits. They did have some allegations in there that were kind of important, but the judge is pointing out how big of a request it is to invalidate millions of people's rights to vote. Can they? Yes. Should they? Probably. Will they? It's not us in that chair. So. All right, guys. That's what I got for you today. Thanks for hanging out with me. I am eternally thankful for you guys making the show possible. And on this Thanksgiving Day, I would like to extend that thanks to you. I hope you all do. I hope you all do have time to be around the people that you like, to be thankful for the things you enjoy, and to forget just for a day the things that you don't have. And just sit in some contentment over what you do have and be thankful for it. And more importantly, who you do have, because that at the end of the day is some of the most important stuff. So thanks for sitting with me. I'll play the outro. We'll see you tomorrow. Again, we'll go into we'll do a quick hit on the Pennsylvania case. I'm gonna see if I can read through some of the Michigan case on my own. I can't promise I'll do that. I'm gonna look into the Nevada case, and we've got the Senate hearing stuff, plus whatever else may come up, plus anything else. Oh, by the way, make sure you go out and do the Black Friday thing, because apparently the virus is not transmittable at a retail store with sweet sales. You can get the virus anywhere else, but not at a retail store with sweet deals for you on Xbox and televisions. Malik Foxon says, hey, Rag, it's late and gay, but I caught up in Among Us with friends. Ended in one person getting salty because they suck at deflecting accusation. Mostly fun. Happy Thanksgiving, bro. Hey, you too. And then Bad Vibe says, I didn't know you knew my mother. Oh my gosh. All right, guys. Whew. Thanks a bunch. Have a good night. I'll talk to you soon. Ah! I have the music muted. 1 second. Here it comes. Here we go. Have a good night, guys. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an art bag, a bow, more a love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plentiful, from Dante to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed